The first one I want to talk about is the BIA decision that just dropped August 13th. People with advanced parole leaving the United States and trying to come back in might have drastic consequences because a precedent that's been here for 14 plus years has now been completely reversed, especially for DACA recipients. Anybody who was on DACA knows that they get married to a US citizen or their children become US citizen and their parents become US citizen, petition them, they get an advanced parole, they leave the country, they come back in, they adjust status, they get a green card. That path can not longer work anymore. They might also need to require a waiver. Let me explain. In the past, one of the biggest barriers for DACA recipients to be able to adjust status and to get a green card was the fact that they might have entered the country without inspection, right? They were brought here as children, they didn't enter with inspection, and then they were overstayed and they have been here for a long time with unlawful presence. Now, even if they get married to a US citizen, because they were never inspected, they couldn't file for adjustment of status, even though DACA protected their status somewhat. In the past, under the BIA rule since 2012, if you get an advanced parole, you leave the country to visit your family for humanitarian reasons, to work, to study, and you come back into the US and you're paroled back into the US, you're admitted, you're inspected, it doesn't trigger any unlawful presence bar, so later on you file for adjustment of status, or you continue with the adjustment of status, and you can get a green card. We've done that for the past 14 years for so many DACA recipients up till now. With this new rule that's in place, even if you have an advanced parole and you leave the country, that is now considered a departure, and that triggers the 10-year bar. Meaning, if you have over 1 year of unlawful presence in the United States on your record, you leave the US, you come back in, that departure constitutes a 10-year bar, and now you're required to file for a waiver for that 10-year bar. Even if you're married to a US citizen, you might now be forced to file the 601 application. Before you didn't have to, now you have to. Unfortunately, if for some people who are not married to US citizens, maybe both parents are on DACA, for example, or they just don't have green cards, if only your children who are US citizen and only they are petitioning you, then you have to prove the waiver, but children don't qualify. So this new rule that went into effect, this new law that reversed the prior BIA's decision, now basically closed the door on DACA's ability to get green cards. This rule doesn't apply to the past, so meaning if you've already entered with the advanced parole, you already left and entered, you might still have a chance. Do your best to make the argument in your adjustment of status interview. But if you just received your advanced parole, you haven't left the country yet, that is extremely dangerous now. Now, we think customs officer will still let you in, even though you have an advanced parole, although that is still yet to be tested, right? There's no 100% certain. And even if you are successfully entered into the country, when you file for adjustment of status, could it still be denied due to the unlawful presence, due to the 10-year bar being triggered? It is a complete reversal. Nobody saw that coming. Everybody was waiting for a pathway to citizenship for all the DACA recipients. Now one additional door is slammed in their face, and that becomes much more difficult. Now, this doesn't apply just to DACA recipients. This applies to all advanced parole holders, right? And for anybody who doesn't know, advanced parole is you are in the process of applying for a green card, and sometimes it could take months or years before it gets adjudicated. And what if you need to travel? So you pay the extra money to apply for this travel document to authorize you to leave and come back into the country. For some people who are in this process, they came in as a visa waiver, they got married, and then they applied for adjustment of status to try to get the green card. Some people were here as a student and they fell out of status and they got married and they're applying for adjustment of status. Many of these individuals, their legal stay have expired. And now when they're filing for this adjustment of status, they're on authorized stay because they're married to a US citizen and they're applying for this advanced parole. That advanced parole, in the past, when you leave the country and come back in, there was a legal fiction that pretends you never left the US. That was the way it was structured. It was written clearly in the case law. You leave the US, you come back in, it's as if you never left. You're still as if you're in the US. Customs still lets you in. Now, if you leave the US with the advanced parole, you come back in. At the interview, the officer will deny your case or request you to file a waiver if you qualify. And for a waiver, for an unlawful presence waiver, you need to have a spouse or parents who are green card holders or citizens. If you have children who are citizens or children who are green card holders, that's not good enough. And so this rule effectively will impact millions of people across this country. Happened overnight. It is shocking. Most people don't know the pain that that entails. That basically forces people to have to write a biography to show that without them in the country, a US citizen or a green card holder will suffer extremely, so that the US government, to protect their own, in a sense, forgives any sort of unlawful presence. The amount of work that is created to do a waiver. We do a lot of waivers, and each one we do, easily 700 pages, 1,000 pages. We usually spend 6 months or longer. We have everybody come together to support. We have pastors, we have psychologists, we have all these people writing affidavits and letters and friends and family and trophies and Instagram posts and all these like family yearbooks to show that this person is good. Unlawful presence is without their ability to control that, and that they are a net positive for America, right? And that without them here, the family would suffer extreme hardship. In the past, if you're married to a US citizen, you don't have to do that waiver. Now, if you have fraud and misrepresentation on your case, if you have criminal history on your case, sure, they might still force you to do a waiver. We don't know. There's other gray areas. What if you only have unlawful presence less than 1 year? What if it's 360 days? It doesn't trigger a 10-year bar, but you still have a 3-year bar. What are you going to do, right? And so it's going to be up to the officer's discretion. We also don't know, what if you applied for advanced parole a couple months ago and it just got approved, or it got approved, or it's going to get approved tomorrow? If you leave now, will that still trigger? Most conservative immigration attorneys will probably say, yes, it will still trigger because the law went into effect immediately. The case law went into effect immediately. So even if you got the advanced parole and you relied on it, you still shouldn't leave. We still can make the argument that, when you applied for the advanced parole, that was the case and you relied on it so you could leave the country, come back in, you could still adjust status. That's definitely risky. We're definitely on the more conservative end. We would not recommend that. Now, if you don't have any unlawful presence issues, you were, unlawful status, and then you filed for adjustment of status while, you were still, your I-94 didn't expire yet, you were still in, lawful status here, and you're on authorized status, you never accrued any unlawful presence in the United States. So this advanced parole issue wouldn't trigger any 3-year, 10-year bars. This story doesn't apply to you, but it does apply to millions of people in this country.